Hello, my name is David Nachman. I'm one of the managing attorneys at the NPZ Nachman Fawani Zimochek Law Group. We have offices located in Ridgewood, New Jersey. We also have an office in Midtown Manhattan. We have affiliated offices in Mumbai, India, and we also have an affiliated office in Canada, where we have actually Canadian practicing lawyers here on our staff, one of whom is Felicia Zeidman, who's with me today. And Felicia is also, in addition to being a Canadian attorney and a former prosecutor, she is also a U.S. attorney, and she works with us on cases dealing with U.S. immigration and also Canadian immigration. As many of you are aware, under the North American Free Trade Agreement, there's a specific provision for the E-visa, which is a treaty trader visa, and that's what we're going to talk to you about today, is the E-visa investor visa. And we're going to talk about it within the context both of the E-visa itself, which rolls out to many different countries, but also specifically with regard to the E-visa and Canada under the North American Free Trade Agreement. So, first of all, what is the E-visa? A lot of people who call our office, they often have questions about investor visas, and they get a little confused with what's called EB-5. The EB-5 investor visa is for green cards. That's for individuals who are coming to the United States permanently, but a lot of people, and that's if you're investing, let's say, $1 million in a business, or $500,000 in a business that's in an employment sort of a bad employment area, which are designated by the Departments of Labor in the states that have those designations. Then there's also something called a regional center. So those are on the green card side. Those are the EB-5 classifications. But today what we want to talk to you about is the non-immigrant investor visa. That's the E-2. And the E-2 is kind of interesting because it's not a creature of the U.S. Department of Homeland Security, and it's actually a creature of the U.S. Department of State regulations. And there's a pretty good body of law in the Foreign Affairs Manual that deals with the E-2. But where we see the E-2 is in situations where individuals are looking to put money into an organization in the United States and then to do business here in the United States. So, Felicia, what's the first thing that you have to think about when you're doing, the creation of an investor visa? What's the first thing that we need to take care of?
We look at the corporate formation to make sure that we've actually got a corporation either in the works or actually existing here in the United States. So we want to have a company, a standard company, here in the U.S. With that being said, we also want to see some funding going directly to the company. Do you want to talk
Exactly.
about that?
Well, actually, with regard to the, let's talk a little bit about the corporation itself, because sometimes, as Felicia's pointing out, you might have a situation where a corporation is already set up. So you might have a situation where an individual is coming to the United States who wants to invest money, but the company is already set up. Maybe the company's owned by someone else, and the individual is buying 51% of that company. So the key, of course, is in order to get an investment vehicle or investment organization in place, 51% of the U.S. entity has to be owned by a national from the treaty country. So for example, let's take a Canadian national who's coming to the United States who wants to invest money. What they want to do is they want to, let's say if the organization is already in existence, they can buy 51% of that organization, own 51% of the stock, and that gives them the investment vehicle to allow them to make the investment and then to apply for the investor visa. Now, generally speaking, Canadians are visa exempt, which means that they don't have to apply for a visa. However, the E-2 is a permutation on that, where they actually have to go to the U.S. consulate abroad and they have to get that visa stamp in their passport. So they have to go to the U.S. consulate offices in Canada to get that visa stamp.
And what you're saying is interesting, that the E-2 is this alternative creature, really, and that what it also does for you is it allows you to be in a business here in the United States. So a Canadian can come here. They are exempt for coming to visit, and they also have many exceptions under NAFTA that allow them to come and work here in the United States or do business here. But an E-2 allows for something quite unique, which is to set up a business and to push it forward while you're here. Put some funds at risk, very important part of the equation.
Clean funds at risk, which means that not only does the money have to be at risk, but it also has to be clean money, and it has to come from a source which is not a problematic source. So you have to have clean funds.
It's interesting that you're using the word clean. I think I think that what you're saying is unencumbered funds, and and there are different ways to find these funds, even through a mortgage, a personal mortgage, for example. There are different ways to find these funds, and by the way, there's different ways to set up the corporation and to find yourself in ownership of 50.1% of a company too. There's different kinds of arrangements that can be made with the non-treaty national, in other words, the American citizen who's sitting here in the States, who would be owning the other 49% of the company.
Exactly.
So, all of these things, I think that for anybody who wants to come here and push a business forward, the E-2 visa is a perfect visa, and it's an underutilized visa, David. I have been reading about it a lot.
It absolutely is an underutilized visa. One of the reasons why I believe it's underutilized is because people look to other types of visas, because the E does have one particular deficiency, which we as immigration lawyers look at, and that is that it's not dual intent.
Correct.
And because of its non-dual intent nature, we're always looking for more powerful dual intent visa classifications, because generally speaking, business people who come to the United States and set up operations tend to want to go in the direction of getting the green card. So there are certain limitations.
So what David means in a plainer English is that when you come here on the E-2 visa, you're here for 2 years at a stretch. The visa is good for 2 years, but it doesn't have any path to permanent residency and ultimately citizenship, which a lot of people want to have. You're just here on a visa to do business, to make money for yourself and make money for the country and hire Americans. And that's kind of the overarching philosophy behind this visa. And so they'll let you come here and do it, but they're not going to let you necessarily stay. Now you can switch over from something like that. You can get a foothold here and you can move into something that is green card oriented, or you don't have to start with an E-2 if you are already having a company overseas and can put a branch of the company here. There are other options, notably the L, that take you into permanent residency. So that is a big deficiency with the E, but I am finding more and more people coming to me who are ready to lay back on the permanent residency. That's not what they need. They want to enjoy the business environment that America gives to them. It is different than most places in the world, as we all know, very business friendly, and they have something to give, and they want to just be able to travel back and forth and to do business here because they see that the culture is going to allow their business to grow, and it's going to let them make money. So that's what they're thinking.
Exactly. So the most important thing for you to look at least in the initial analysis, is do you come from a country? Do you hold a passport from a country that is a treaty country?
Oh yeah, that's
because
important.
You have to make sure that there's a treaty, and it's usually either there's a treaty of trade and navigation between, a treaty of investment between the United States and the foreign country, or there's a bilateral treaty of trade and navigation and investment between the United States and the foreign country. If there is that treaty, and you own 51% of the organization, or to make it really clean, what we like to do is set up LLCs here in the United States and have the prospective investor own 100% of that organization, because then you're not leaving any question in the mind of the officer as to whether or not it's an investment vehicle. And as Felicia properly pointed out, it's really nice because you get 2 years, but the way it works is that depending upon what country you're from, it's actually based upon reciprocity. So what it is that you could get a stamp, depending upon what reciprocity exists between the United States and the foreign country, you could get a stamp for 10 years, and then every time you come and go, it renews itself automatically for 2 years. So that's a really nice opportunity.
Right, so 2 years is a bit of a misnomer, because for most people it's between 5 and 10 years that the visa would actually be
good.
Right,
yeah, exactly.
be good for. You need to, that's a discussion you should have with your immigration lawyer.
Exactly. But it's an excellent tool. It's a great business visa, and there is discussion out there about the possibility of them considering the E to maybe have some dual intent in the future. And generally speaking, that we tend to find that our clients who travel back and forth, they are able to, although there's no dual intent for the e-visa, the government does most of the time treat the e-visa holder as if they have dual intent. So it's like, even though they don't have it, they treat them like they do. So it's really kind of nice. One of the other things about the e-visa which you need to know is that obviously if the e-visa holder comes into the United States, the derivative gets employment authorization.
That's a good point. Meaning that if you come here with your spouse and your spouse is looking to do some kind of work here in the U.S., they will be employment authorized as the dependent upon you, the E-2 holder. So you don't have to come here alone and leave your spouse at home, and your kids for that matter. You can bring everybody, and the kids can go to school, and your spouse can participate in the workforce. You know?
So once the derivative visa holder comes into the United States and they get it's called an E-2, they also get E-2 visa status. They're allowed to apply for an employment authorization document, and they can engage in free market employment. So their visa is not tied to the organization. They can basically go to work anywhere.
Right, that's a very good point.
And that's just a spouse.
Yeah.
So the big question which I get all the time, Felicia, whenever people call me up about the E-2 visa, they want to know about how much money do I have to put in?
Yeah.
That's a big question. And then what does my business plan have to look like? So let's address those two issues for our viewers.
Okay, the amount of money that's required is completely related to the type of business that it is, but it's never advisable for it to be an amount that is marginal. So they don't want you to come with your savings from your part-time college job and set up a consultancy in computers. I think the objective is to have a very significant, there's another term that's related to the amount of money, which is the term having funds at risk. So it has to be a certain amount of money, and that money has to be at risk, being that it's invested in the company already. If the enterprise is a bricks and mortar type of enterprise, they're going to expect you to invest bricks and mortar type of money.
Exactly.
So that can mean buying a property or renting a property long term, or let's say you're going to do you're going to build you're going to resuscitate old high end cars. Okay, so they're going to want to know you put some money into getting the cars into your shop for the purposes of the work. Maybe you've already started to employ somebody, or you're looking at an employment agreement with somebody. Some of this stuff can be contingent, so there's ways around it, but the kind of funding that you're looking for is directly related to what you're doing. And I think that it's important that the more money that can be shown to be invested, the stronger the application is.
Absolutely, there's no question about it. The three legal terms that they use are marginality, proportionality, and there's one other term. But basically the idea is that you have to show you have enough money to be able to run the business. What Felicia's pointing out is absolutely correct. It's like if you're coming to the United States and you're opening up a Mercedes-Benz dealership, then if you have only $50,000, you're going to be lucky if you can have a hubcap on your lot. But if you have $250,000, you may have a couple of cars. That is going to show the government that you have enough money to be able to really do business. So let's also talk about the strength of the business plan. It's really important to have a good solid business plan and to crunch your numbers and do a pro forma. Pro forma means to kind of look out at what the future of the business could possibly hold once it gains a foothold in the United States. So it's really important to have a good business plan. We always recommend, we actually work with certain providers who actually do nice business plans, and We tend to find that the stronger the business plan, with all of the bells and whistles that are necessary, it seems to make the government officers very happy and in tune to what's really going on in the business.
Mm-hmm.
So, and now what you also need to know about processing the e-visa is that there are two ways to do it. Generally speaking, you would take the application package and you'd go to the U.S. consulate and you would make the application directly at the U.S. consulate abroad. However, if the individual is in the United States and they do have status, they can file for a change of status in the United States to e-visa. So one of the questions that I always get from clients is, well, which one is better? So because the U.S. Department of State because the E-2 visa is really a creature of the U.S. Department of State, sometimes it's better to process in the United States because the USCIS is more willing to afford, to give deference to one of its sister administrative agencies, whereas maybe a more hard line might be taken by the officers at the U.S. consulates abroad.
That's a hard one. That is kind of a hard call, and sometimes it has to do with what consulate would be consulted, or would be what the home consulate is of the person, and what we know about those home consulates. That's
Exactly.
important too.
But it's always important if you're thinking about doing this type of visa, or you think that this might be an option that's available to you. Of course, the best thing to do is to seek proper legal advice. Make sure that the person or the firm that you go to is familiar with the e-visa and how the investor visa works, and that firm should be able to guide you step by step through these issues which we've just discussed and laid out for you. So with that, I'd like to thank you very much for tuning in, and if you have any questions at all about the e-visa or about investor visas, please feel free to reach out for Felicia or myself or any of the lawyers here in our firm. We'd be more than happy to assist you.
Thank you.
Bye now.